Well, guys, we are going to discuss an important topic today. This topic is custodial violence and analysis. This article is based on today's Hindu newspaper article, The Importance of Being Human. Yes, we will see that the definition, causes, solution of custodial violence in India. So let's see. There is no exact definition of custodial violence in Indian Constitution, provided that it is protected by constitutional and statutory provisions of various clauses of Indian Penal Code and Criminal Procedure Code. There is no exact definition of what is custodial violence. It has not been defined in Indian Constitution. Instead, there are various provisions of Indian Penal Code and Criminal Procedure Code which have deal with custodial violence in India. So let's see. So first, it is clear that though there is no exact definition regarding custodial violence in Indian Constitution, but various provisions of Indian Penal Code and various provisions of some articles of Indian Constitution and some sections of Criminal Procedure Code have dealt with custodial violence. I have collected two definitions of custodial violence given by Law Commission of India and Justice B. Reddy. You can quote it in your exam wherever you find the relevance of this. If you want to copy the whole answer, you can go to my Facebook page, Singularity IAS. There you will find the answer. Either you can go to our website, learnwithmaster.com, from where you can copy the whole note regarding custodial violence. So first we have seen the definition, provisions of custodial violence in India throughout the help of Constitution, see Criminal Procedure Code, Indian Penal Code. Then let's see what are the two types of custody in India. There are two types of custody in India called police custody and judicial custody. Police custody means what? When a person has been arrested by a police, right from that time up to the time when the person has been remanded for police custody. Means if a person is arrested, right from that time, when the person is has to be remanded by police custody for maximum 15 days by magistrate, the whole period actually calls police custody. Means the time from arresting a person up to the time magistrate remand the person to police custody, or up to the time the person gets bail, the whole time period, the whole span of time from the arresting up to the getting bail, right? Yeah, up to sending a person to jail, the whole span of time is called police custody. Then judicial custody. Judicial custody means what? The time period within which a person is confined within jail temporarily or permanently. It is judicial custody. Judicial custody means when under state law a person has been sent by a magistrate to a jail for permanently or temporarily. That is judicial custody. Police custody means right from the time of the arresting up to the getting bail. So let's see causes of custodial death in India. Sometimes police has to beef up information within short period in the fear that criminals will get bail because of lack of proof, tampering evidences, etc. causes inhuman atrocity. Sometimes police have to act promptly. Yes, sometimes police have to act in a very hasty way because dealing. They will find very less time because delaying because inability to prove the arrest of the causes with sufficient ground before the magistrate will cause the release of the person. That is why they take inhuman approaches so that they can take out the information from the accused person. Sometimes a police officer, to prove himself prudent in solving a case quickly in front of superior authority, adopts inhuman torture. For example, sometimes a police officer wants to improve his image in front of his superior authority because of promotion or other advantages, so he tries to solve a case quickly, taking some inhuman measures to take on information. The outrage and opinion of society. What does that mean? Sometimes the whole process is influenced by social opinion, because society was in some cases who is have relevance to society. Yeah, who is society demands more immediate actions than the police bowing down to such a public opinion and social opinion. They have to take some quick actions to take out proof from the accused persons. The corruption of police officials to receive money. It means what? Sometimes police wants to take on money. Police are aware in advantage of taking money. They how to liquidate money from the concerned person, from the family of the concerned accused. That is why they try to imprint torture. Right, they try to impose torture on the accused person so that his family, yet a person compels to compromise with the police in exchange of a hefty amount of money. The lack of scientific criminal investigation system, lack of proper training to official means how to investigate properly using some scientific technique, using some psychological approach. There is no existence of such kind of procedural criminal investigation system based on science. Lack of proper time for an officer to dedicate the investigation. In India, a police officer, as per some survey, gets very less time to investigate a case because they have to dedicate their time for the protection of political persons or some other unnecessary cases. That's why they want to solve the cases immediate way, using some inhuman approaches. Violence in jail, pathetic humanitarian conditions under trial prisoners. We all know that what are the conditions, what are the pathetic and pitiable conditions of under trial prisoners in India. In such cases, violence as well as other some psychological pressures also causes some custodial death, custodial violence. Nexus between doctors and police authority often leads to erroneous report. In case of custodial death, sometimes what happens, there is a very strong tie between police and medical officers, and the medical officers often get erroneous report to help the police officers. So these are some causes who is actually determines the prevalence of custodial violence, custodial death in India. So now let's see the protection from custodial violence. What are the various provisions of protection of custodial violence in India? So National Human Rights Commission guidelines 1993 that says that if a person if a person is arrested, he must have to be mandated within a magistrate within 24 hours. And any post-mortem process, if a person dies in custodial violence, then the post-mortem process, the whole post-mortem process has to be videographed, followed by a ministerial inquiry into the death. If a person dies in if a person dies in police custody, then a judicial magistrate has to inquiry into the death. The whole post-mortem process has to be videographed. And as soon as the whole report, within 24 hours, the report has to be, the death report has to be informed to the National Human Rights Commission. As far as Indian Constitution is concerned, Article 20, Article 21, and Article 22, these three articles are related with the protection of person in a police custody. Try to find out what are those articles. You can also copy paste the whole note from our website or from our Facebook page, as I have mentioned in the initial phase of the lecture. Number 6, Kharak Singh, MP Sharma, and Puttuswamy case. The three cases are also directly or indirectly related with the custodial protection, because in all these cases, Supreme Court says that privacy is an inalienable right of the person. That privacy cannot be separated from the individual right of the person. So police behavior to infringe on private rights of a person to gather information without the procedure established by law invites a violation of law. Section 348 of IPC, wrongful confinement of any person for extorting confession is a punishable offense. Section 330 of IPC, voluntarily causing hurt to extort confession is a punishable offense. Section 25 and Section 26 of the Indian Evidence Act are very, very important, because as per these two sections of the Indian Evidence Act, a confession given by a accused person in police custody cannot be proved in court, is not admissible in court. This is because to protect the person from inhuman torture of the police custody. A person can say anything being caused by inhuman treatment of the police in police custody. That is why this section 26 and 25 of Indian Evidence Act says that a confession given by a person in police custody cannot be proved at cannot be proved as inseparable ground. Section 76 of Criminal Procedure Code, then an arrested person must have to be produced in court without any delay. Supreme Court guidelines in DK Bosu versus West Bengal cases that police must have to identify the person before arrest. A memo writing the time of arrest signed by an independent witness countersigned by the accused must have to be prepared. As soon as the person is arrested, his nearest kin must have to be informed about his arrest and about his detention place. An arrested person must have to be produced in court within 24 hours. An arrested person must have to be medically examined to identify any injuries so that later injuries caused by police custody can be signified. National Human Rights Commission and state human rights commissions have been established under Protection of Human Rights Act 1993. India has signed various treaties like Universal Declaration of Human Rights, International Convention on Civil and Political Rights, UN Convention Against Torture, which has projected India's humanitarian image. But there are some existing loopholes. Loopholes are what? Uh, there are some linguistic loopholes, like under Article 36 of Protection of Human Rights says matters not subject to the jurisdiction of Commission. State governments often find this clause to overpass the vigilance of National Human Rights Commission. The power of the Human Rights Commission is confined only to recommendatory nature. Section 15 of TADA Act, though it is lapsed, and Section 32 of the POTA Act has diluted the Section 25 and 26 of Indian Evidence Act. Section 45 and 197 of Criminal Procedure Code gives immune to members of armed forces and public servants for any activities done under the ambience of their official duties. These are some existing loopholes throughout which the custodial violence is continued actually, right? To find the exact note, you can go to our website, go to our Facebook page, because it is very difficult to say everything here. Towards the end, I have given some solutions that what can be solutions, that a constant vigilance regarding human rights commission is necessary, right? Allotment of proper time to an investigation officer, sensible training, adoption of scientific inquiry, a debate regarding the controversial sections, a humanitarian and sensible viewpoint, proper implementation of Supreme Court guidelines, improve conditions in jail, fasten the judicial justice delivery process, create awareness and active participation of civil society organizations, etc.